How to get your DWI dismissed in New York. A DWI charge in New York feels overwhelming, but the truth is that many charges carry hidden legal vulnerabilities that a strong defense can expose. Under New York Vehicle and Traffic Law, Section 1192, the prosecution carries the full burden of proving the specific charge filed against you, and that burden is not always easy to meet. Whether the charge is a per se DWI with a BAC of 0.08% or higher, an aggravated DWI at 0.18% or higher, or a common law DWI based on observable intoxication, each requires distinct and admissible proof. One of the most powerful defenses begins before a single test was ever administered, by questioning whether the officer had legal justification to pull you over in the first place. Police generally need probable cause of a traffic violation or reasonable suspicion of criminal activity before initiating a stop, and driving late at night or leaving a bar parking lot simply does not qualify. If the stop itself was unlawful, any evidence gathered afterward, including breath test results, field sobriety observations, and your own statements, may be challenged through a suppression motion. New York breath test evidence can also be challenged by examining whether the device was approved, properly calibrated, and operated by someone holding a valid permit at the time of testing. Before collecting a breath sample, an officer must observe the subject continuously for at least 15 minutes, ensuring the person does not eat, drink, smoke, vomit, or place anything in their mouth. If that observation window was not properly maintained, mouth alcohol contamination could have skewed the BAC reading, and the defense may have grounds to challenge the result. Standardized field sobriety tests, including the Horizontal Gaze Nystagmus, walk and turn, and one-leg stand, must be administered according to strict NHTSA protocols to carry any evidentiary weight. Unclear instructions, uneven terrain, or a failure to account for physical or medical limitations can all undermine how much the court is willing to rely on those observations. Miranda violations open another avenue of defense, because if police questioned you about your drinking while you were effectively in custody without providing warnings, those statements may be suppressed under CPL Section 710.20. New York courts hold pretrial suppression hearings, including Mapp, Huntley, and Dunaway hearings, where the defense can directly challenge the legality of the stop, arrest, and evidence collection before any trial begins. At these hearings, a defense attorney can cross-examine the arresting officer under oath, testing the credibility of every decision made from the moment you were pulled over. Randall F. Inniss of the Inniss Firm, PLLC, served with the New York State Police for more than 22 years as a trooper, investigator, and senior investigator before dedicating over 25 years to practicing criminal defense law in New York. That background gives him a uniquely practical understanding of exactly how DWI stops, arrests, and testing procedures are supposed to be conducted, and where they most often fall short. When you are facing a DWI charge, working with a seasoned lawyer who understands both sides of the system can make a decisive difference in how your case is resolved. Contact the Inniss Firm, PLLC, located at 280 NY 211 St. 203, Middletown, New York 10940, by calling 845-470-4236 to schedule your case evaluation with attorney Randall F. Inniss today.